G'day, Kim. How are
Hi,
you?
I'm good, Andrew. I feel a bit unprepared today. We've both been so busy. We're a bit.
We are.
Hopefully we'll go okay.
It's interesting. I read all this when I set up the structure for it,
Yeah.
and now I'm reading a bit. It's like almost
Oh,
the first
dear.
time I've ever seen it. But look, I think we are going to talk as our major topic today, dishonesty, which is commonly and unfortunately people use the words theft and fraud, and they use them in ways they shouldn't use. So we'll talk about that and the process around what you do when we come to it. But I think that's a really interesting discussion because it's a common one that we have.
Yep.
But just kicking off industrial manslaughter in New South Wales, Kim. So that will be all states and jurisdictions. Tasmania's already there. We've heard a couple of weeks ago they're in the game.
Yep.
New South Wales?
Yep. So they will be introducing industrial manslaughter with 25 years imprisonment and $20 million maximum fines, which will be the highest in the country.
Okay. And we've seen as a side of this, what we are seeing is a ratcheting up of reckless endangerment to go from the 3 million up to 5 and 10 million. So I imagine probably within 2 to 3 years, what we're going to see is that reckless endangerment. I just saw your husband moving with coffee towards you. There you go.
Oh no! Come back!
Rob, what about mine? So we'll start seeing this new benchmark of reckless endangerment now sweeping across the nation at around about 10 million. I think the sentencing discussions in Victorian Sentencing Committee are going to come out and recommend that in Victoria as well. Anyway, that's an aside. Why don't we go on and have a look at HADOS, which is...
Yeah, this is an interesting one. So we've got a proposed agreement before the Fair Work Commission, and the company, road construction company, want to have a clause in their contract that employees are not to use any social media at all during working hours and outside of working hours not comment on their employment at all.
Yeah.
The union are a bit up in arms about this. The employer's basis. The employer says, well, it's a safety concern, and valid. There are 100 or more other agreements with this very same clause in it, but the union are saying in this case that we think they're trying to gag our employees.
That's just nonsense.
Yeah.
Can I just... So look, I wanted to go sideways just for a little bit. So I spent a really good time a couple of nights ago chatting to two leading organisational psychologists. And one of them has said is there is unequivocal evidence now that the use of social media, open office plans, and the nature of everyday life has caused people to reduce their capacity to concentrate and to do complex tasks. Okay? Which is not a surprise, and that is because people work best in a place of flow.
Yeah.
So what they're best at, if they're given an environment where they can do their best, their brain will form a habit of concentration and will follow through that process.
Yeah.
Social media is one of the major distractions and triggers to breaking that, and also the sense of immediacy that now lives in this environment. So we are seeing, not only in children, but in adults, the inability to concentrate for more than 5 or 6 minutes that is being driven by high levels of distraction. So I think that's really fascinating, okay?
It is.
It's fascinating for the structure of our law firm for a start, because I sit in an office for one very good reason: I can actually work. And I put my phone aside for an hour at a time so I can work and switch it down. But the other thing just on this issue is, as I was driving into work today, there was a woman holding a stop sign.
On a phone?
And she was looking at a mobile phone. And I thought, probably social media.
Yeah.
So I think banning it during work hours is a really good idea. And if you don't have a use for a phone, don't use it. It's
especially
just,
in networking.
Yeah. But secondly, all that is in the enterprise agreement is what O'Keefe and a number of other cases say about that employees out of work cannot say or do things which interfere with the safety of people at work or the reputation of the business. And that's what Regulation 107 says.
Yeah.
So it is a bit of a storm in a teacup, but I think it's a great discussion. Because at some stage, we've all got to look at each other and say candidly, how do we regulate the use of social media? Because it is so disruptive and the behaviour of it is so bad, we need to get some controls because the owners of it won't. All right, Alicia and Vision Australia. So we're in the High Court. This is a case that's gone off to the High Court. First submissions have just gone in through Vision Australia. The background of this case is, in very simple terms, the process of termination caused a person to suffer mental health issues. And
so post their employment.
Yeah, post their employment.
Yeah.
And Addis is a case which says it's not compensable. Okay, and that's a case which I think was originally an English House of Lords decision, but that's
long time ago,
yeah. But it's been held as good law repeatedly by federal courts. So it is the precedent of law in Australia.
Yeah.
Couple of issues about this we've talked about in the past. One is this is a true plaintiff personal injuries law firm that's running it. And I've talked to you about what the risk is, because we've got a whole institutional structure that sits around termination of employment and restricts your access to damages and compensation as a result of that. And so if a common law right arises, what we'll see is a massive shift in the way, particularly more expensive employees litigate their claims, because the opportunities are much larger. So that's one major structural problem. But the other part is, as a matter of common sense, the law of ADIS sits outside the general law of negligence and contract. It doesn't make sense. If someone causes a harm and has a duty of care as you to an employer to treat you safely, the fact that the injury arises afterwards should be no barrier to it.
Yeah.
So, fascinating case, okay, because Vision Australia have said exactly what you predict. Well, it's the law, LAW. Well, that's not a great argument in the High Court because they make the law.
Yeah.
Secondly, we've got this institutional structure that says this is how we manage it. I think not a bad argument, because Parliament has decided to intervene to provide a structure. But at the end of the day, it does make no sense. If it is successful, so this is just Vision's submissions, the next submissions are late June for the plaintiff in the case.
Yeah.
So we'll probably get a decision in the next 6 to 12 months that comes out of it. But if the plaintiff wins in this case, can I say to you, it will be like the earth moves. It'll be such a gigantic shift in the way that plaintiff law firms litigate, because at the moment, the Shines of the world, those plaintiff personal injury firms, they really don't litigate unfair dismissal. But when they do, there'll be a whole market created around it, and that will change the way defendants, employers, act to respond. So that's why we're giving you update, because I think, we've talked about Little's case last week, which is about how safety affects inherent requirements. Really important case.
Yeah.
But this is the biggest case this year.
It is.
Why don't we go on to the next case? So I think, well, not case, it's really the pay rises.
So,
and can I say to Nina, I said 3.8, it was 3.75, but I was closer than Nina. That's why she's not here today. No, sorry. Over to you.
Okay, so national minimum wage and award rates will increase by 3.75%. The awards that they will apply to are principally around early childhood disability, social workers, and the medical health professionals.
Yeah. Look, I guess the other part that sits in this is just remember, if you're paying over award, you can absorb it.
Yeah.
You don't have to actually add that on. But in this market, with the shortage of talent and with the inflation we've had, think carefully about making the adjustment with the over award part to actually maintain it, because to reduce your employer's actual disposable income in true terms, when we've had underlying inflation much higher than the CPI figure. When we talk about underlying inflation, we're talking about what do we do? We use cars, we have a glass of beer or a glass of wine, sometimes we have cigarettes. I don't, by the way, unless I'm very drunk. But the things that we use, like groceries and things, have gone up considerably more than 5, 6 or 7%. So be aware, you've got people who are actually hurting out there and making very deliberate decisions about how they use their money at the moment. I also noticed the Fair Work Commission is interested in initiating proceedings in 5 areas where there is a clear lack of parity in women's wages. So we're going to see them taking very positive steps to try and get women's wages on par with men. I think that's probably a really good thing that's occurring. About time. You don't do too badly. Come on.
Oh no, we're paid equally. We don't discriminate.
No, we don't. You're the boss. All right. Now let's go to Latouf's case. Okay. Now this is been widely publicised by Josh at Morris Blackburn, who's running it. But it is a good case, an interesting case, but actually it's not that hard when you look at it. She was a casual worker as a presenter on the ABC. She was told not to publish. Let's say with the evidence, it's somewhere like you were told not to publish anything which would be anti-Israeli or pro-Palestinian. Again, the evidence is yet to be determined on that.
Yeah.
She reposted something which suggested that hunger was being used as a weapon of war for Palestinians. They took her off the air. There were a number of people who put pressure on ABC to do it. Doesn't matter. She said, I'm bringing a general protections claim. They said, well, she wasn't terminated. She was a casual worker. And
for 5 days.
Yeah, when we paid her for that day and we paid her for the next 2 days. Can I say, when you're a news presenter and you're taken off the air, it's termination? It's as plain as the nose on your face. And that's really what the Fair Work Commission found. They found, well, it was, and therefore the claim can proceed off to the federal court, where it'll be re-agitated and will be a media frenzy for a whole lot of reasons. But it's nice to see the Fair Work Commission not being caught by the noise and just applying the law.
Yeah.
So it was good.
Yeah.
All right. We're moving through at good speed today. We're right on mark. This is working from home employee. And can I just, as we talk about this, just give a bit of a preface, Kim? We are still in a position where we have not got our hands around what flexible work looks like. We are not clear what are the expectations when people are at home, nor do we seem to understand what happens when you're not in an office. Doesn't mean it's not an office. So behaviour that would occur, which occurred at an office, is as compensable and as is safety risk as when you're at home doing it, which means you must control work environments at home better as well.
Yeah.
That case is not about it, but this case really highlights it.
It does. Okay, so it's during the pandemic, people working from home. Lady decides to go off for a walk, and listens to an L&D podcast, which she was required to listen to for work purposes. Was injured out on her work. Comcare rejected the claim on the basis that the injury did not arise out or in the course of her employment. And it was during I've got to read my notes because my memory's shocking. During a temporary absence away from her workplace that was not approved by the employer or necessary for the performance of her duties.
Yep.
So it comes down to consideration of what the managers knew about, what they approve of absences anyway. Doesn't matter.
Can I just say, just to help you through that?
Thank you. I said I didn't have a lot of time to prepare for this today. Sorry,
didn't
guys.
have a lot of time to prepare for this. No, so if one of my guys goes across the road to get a coffee, they're at work, okay?
Yeah.
If I ask them to do that, obviously at work, but if they're going and doing that as part of being at work, it's still work. So the approval of doing something that is not in a workplace is by conduct. It doesn't have to be express. And that's really the mistake that sits in this case.
Yeah.
If I say to somebody, you got to listen to this, and they listen to it in working hours, and they're expected to listen in working hours, not outside of working hours, and to do that, they go for a walk to do it. Good on them.
Yeah.
So this was always going to be compensable. It was odd that it was argued that it's not, but it shows again how institutions and people are not getting used to the fact that workers' comp legislation and safety legislation is alive at home in just the same way as it would work. So if Kim said, look, I'm going to go down into a coffee shop and listen to this L&D, and someone comes in and falls over and she's injured, well, she's listening to the Learning and Development podcast in a coffee shop, not at work. She's still doing work.
Yeah. And conversely, if you'd said to me, you must do this at this time in this location, you are not to go outside of that environment. That's different because I'm acting contrary to a lawful instruction.
Yep.
So
okay. So look, each week you can tell that I've got a bit of a drive going on at the moment, which is talking about behaviour which occurs that falls outside the workplace and workers' comp. And there's a reason I'm doing it, I guess, because Kim and I commonly come across people who think that the work is a fortress. That only while you're inside work can the law apply. And I guess it's not very, very subtle, is it? But I'm trying to expose through car park cases and a whole lot of other things. When you say people are at work, what does work look like? When people are going and doing things which are regularly part or parallel to the work they're doing, are they work? But can you think about it? Because there are cases repeatedly coming through which are on the edge of compensable behaviour, which just shouldn't be. So if you've got a car park that you provide for people, you say, look, it's absolutely up to you whether you use the car park or not. It's not an issue for us what you do and how you get here. The issue is being here. And that sits in a policy. You could exclude most of the car park cases. Does that make sense? It's not hard to think about it, but you've got you do have to apply your brain to it. And what's happened with flexible work is everyone's so scared of it, so scared of offending someone, so that they won't actually put boundaries around what is work. So anyway, that's enough of my rant on that. Let's go on to Guthrie's case, because I think this is an interesting case.
Yeah, so this is a general protections claim. Guy exercised his workplace right. He asked for flexibility for child caring arrangements, made a complaint about being underpaid, emailed the HR manager pushing for his rights, and they terminated him on the basis, or they claim he damaged property and harassed the manager. So he brought the general protections claim. The commission found that there was no evidence to support the employer's claims. They didn't do a proper investigation as to the alleged safety breaches, and on an analysis of the emails to the HR manager, he was very respectful and he was just pushing for his rights.
Yeah.
So his claim was upheld.
So this is not uncommon, and I don't think Mr. Guthrie was a sort of red flag employee, but it's not uncommon that red flag employees, and that's my expression for difficult people at times, will commonly start to press for things and they'll complain about safety. Some of those complaints won't be right. They'll be wrong. But they have raised a complaint, okay? So when people do that and you're sick of them and you go, oh, they've done it again, we just got to get rid of them. Just don't.
Yeah.
I guess is my answer. Deal with performance and conduct behaviour as it occurs.
Yeah.
We all know with the red flag type of employee, it's always subliminal. It's just beneath the line. So it's driving you crazy. It's the person you sit in a meeting and you ask someone to do something, they just roll their eyes. It's all those sort of slightly subversive behaviours that get to you. You can deal with that. So deal with it because it's misconduct.
Yeah.
But don't wait to a stage where the frustration level builds up like a pressure cooker and they go and do something which may be wrong what they assert, but they're entitled to say it and then go, let's get rid of them. Because not only would this be a general protections breach, okay, this would also be a safety discrimination breach. So you're really looking at damaging a brand. And if you're a supplier of goods which has major procurement contracts like a Coles or a Woolworths, this is a piece of leverage for Coles and Woolworths. This is one of the things they mention you're not allowed. It's a safety breach. They mention, which allows them to terminate the contract or worse still, to start renegotiating on price. So a day of frustration can lead to something much, much worse. And I just want you to go, we manage people on what is good every single day, both on their performance and their conduct. We don't let things build up, and we certainly don't respond adversely when people tell us bad news and it just shits us and we go, I can't take this anymore. And this smells of a case which is, I just can't take it anymore, doesn't it? All right, why don't we have a look at Kerry and Red Metal?
Oh, okay. Yep. So this is a death claim.
And can I again, I just want to preface this a little bit to let you collect your thoughts. No, one of the things, particularly in New South Wales and the definition in New South Wales, but in all states and jurisdictions, there is this capacity to bring a claim where you can show the nature of the stress that was caused at work could lead to death, or in other cases, not even that, even to injury. Okay.
Yeah.
So it can lead to incapacity, and we've had cases in New South Wales where heart attacks have happened because of psychological hazards building up in a place, and they showed that there was causation, work was caused. So what we thought today is we'd put in a case which really highlights how that plays out, where a death has occurred through a heart attack, which 10 or 15 years ago, not many people would have thought about litigating.
No.
But anyway, over to you.
So typically the legislation in work cover provides that if you've got a heart attack or stroke injury, it's compensable if work is a significant contributing factor to that stroke or heart condition or attack. In this case, a gentleman with a heart condition worked in very high temperatures, and the medical evidence was able to demonstrate that those high temperatures did precipitate the heart attack, and the wife and children were able to bring
a death benefits claim. Yeah. So look, interesting, isn't it? Actually, in Vietnam, it's been so hot at the moment. There's been people dying in rice fields working. That's how hot it's been. I do want you to understand that physical stresses, not just psychosocial stresses, can create real risk. And so particularly when you've got people working on road gangs and construction in hot weather, yes, the award reminds you when you do and don't have to work in hot weather and in cold weather, but be mindful of it because it does place major stress on the body. All right, I think we're over to our major topic, aren't we?
No, we've got the little boy who drowned, unfortunately.
Oh, sorry, we do, don't we?
So safety case, Andrew, you might want to talk about this given it's your expertise.
I would if I had read it.
Oh,
yeah,
okay,
no,
I'll
no.
do that. No. So kids going off to a school camp using a swimming pool. The school inquired of the parents the level of swimming ability. School didn't pass that on to the pool.
Yep.
And the pool didn't make a proper assessment of the children's swimming ability before they threw them in the deep end. And unfortunately, little boy drowned.
Yeah.
So safety prosecution. I think these are really low fines, I've got to say. The pool operator was convicted and fined $80,000.
Yep.
And the Department of Education, $100,000.
Yeah.
Seems very low to me.
Look, it does, but it's hard, isn't it? Because the reality is, and school industry is one of our major industries, and I'll be actually chatting to principals later today. One of the issues around it is, what is the state of knowledge do you need of a child? So you need their health status, you need their swimming capability, but you're relying on parental information, which may not be accurate. So the reality is, when a child gets in the pool, unless you've satisfied himself of the swimming capability, you've got to be satisfied of the swimming capability of the child before you don't supervise the child. And equally around health status, you've got to be vigilant and aware when you've got young kids in pools. So I think, like many things, this is sort of the beginning of an attack. This is our third schools case this year. So we're starting to see schools being targeted by regulators around the care of children in a way that hasn't occurred before. But look, let's be honest about this. I would not accept what a parent tells me about a child.
Well, no, the parent was accurate in this case. The
I
parent
know, but I'm just saying, but I wouldn't be, because what about the competitive parent who says, oh yeah, my child's a great swimmer? You know, just think about your own parenting skills. Maybe not you, because I think of mine, they're not that great. I'm not sure I'd be a reliable resource. I would expect that someone who manages my children in the pool would at least
do their own due diligence.
Do their own due diligence about it. And that's really, I did read this case. That's really what this case is about, is the pool operator failed to satisfy itself as to the capacities of children who are inherently vulnerable, given their age, size, and skill base, and failed to appropriately carry out the risk assessment and supervise. So,
and that's it, isn't it? It's, the higher the risk, it always comes back to the higher level of control you need.
Yeah, well, Moon goes swimming every Sunday, and they do it in a low area of pool. And as a parent, I was looking at my phone, and someone tapped me on the shoulder and said, your child's under 10, you're not allowed to look at your phone. Okay.
Bad parent.
Bad parent. Anyway, I just admitted that on sort of national television. No. Okay, come on, let's get on with it.
Okay, main topic.
All right, look, can I just tell you the background? There's three things I want to concentrate on. One, stop using names like theft and fraud. Okay. It's just dishonesty. Okay. Theft and fraud actually do have real tests. So as in the case when I talk about, it wasn't theft, could never have said to be theft, even on the facts they had it. When we're dealing with financial dishonesty, you've got to understand that the first rule is the method of investigation must be one that can withstand criminal investigation. Okay, so that means proper witness statements, proper evidence collected in an appropriate way. Okay, so I just want to be very clear. The investigation process is one which must be forensically well done, and the evidence collection must be able to produce evidence which, if it's drawn upon in the criminal court, is admissible as a matter of law. It's not easy, and you need help. The second thing is, one swallow doesn't mean a summer. In other words, a person makes a mistake. Now, they may have done it dishonestly, they may not, but that's a state of mind. So if someone's spent or grabbed $5 worth of something and not paid for it, just don't overreact. And the case we're about to talk about is the overreaction. And the last part about it is, make sure that your systems aren't the problems. So when we're talking about theft, we're talking about fraud, or we're talking about financial dishonesty, the one thing you must learn in the investigation process is, what are the flaws in your system that permit it? Because you and I have both dealt with financial theft on a large scale by bookkeepers, $4 million, $2 million, which have gradually been taken out of a business. So like all bad things, good things come. And when the good thing that comes is you get a chance to dig deep on dual signatures, system analysis of where was the problem that arose. So they're the only things I really want to concentrate on today. The case tells us something else, which I think is really helpful. But you want me to talk about the case? Or
I'll just talk about the facts quickly. So we've just got a duty manager at a club, like an RSL type club, who had a drink and didn't pay for it and thought they had.
Yeah.
But they were terminated as a result, brought an unfair dismissal claim. The
Commissioner thought she was credible.
Yeah.
Yeah, thought she was credible, reliable, made sense, and then go move on.
Well, but applied the wrong standard of proof.
Yeah. And isn't it odd that even at a quasi-judicial level, that's being very generous, isn't it, that you don't know the law? So what happened to the commission is that they said, well, the test is beyond reasonable doubt. You said it's theft, so it's criminal duty. Well, I think all of us know it's brigandage, which means if you're going to allege something which has dishonesty, and the more serious the nature of the offence, the clearer you've got to be with the evidence that you rely upon, but is still on the balance of probabilities, more likely than not. So it was then appealed, and they said, well, that's actually not the burden, but anyway, I think you're right, she didn't steal it. And you should be very careful about using the word theft. So brigandage is a case when you're doing any investigation for any serious allegation, whether it's sexual harassment, whether it's theft, whatever you say it is, you must think carefully, go online, read about brigandage. If you're not sure, give Kim a ring. It's not as simple as saying, yeah, when I think about it, it's more likely than not. You've got to be looking at the quality of the evidence that you're relying upon. Now, what happens if it's a she said, he said brigandage? Okay. Don't be put off by credibility arguments, because there will be other real evidence that sits around what the people say. Like the person who said they didn't do it said they weren't there at that time, and you'll have records that show, and CCTV that shows the person either was or wasn't there. So the idea of evidence is using Shrek's theory of an onion, is to go out and layers. I think it was Donkey's theory, actually, Shrek, but anyway, you can see I've still got a 7-year-old, can't you? But when you investigate, you start off with real evidence and direct evidence, first layer. Then you look at the circumstantial evidence. What are the things that sit around that test the truth of the real and direct evidence? You start moving out, and Kim's great at this in her investigations. And from that, you go out and you look at indirect testimony that sits around, and you look at history of behaviours that occur as well. So actually, there's no such thing as a she said, he said, because there is always extrinsic evidence which gives you the capacity to test the truth of what people are saying. So it's not simplistic, and if you have an investigator, so it's she said, he said, I can't substantiate it, you can give me a clip around the ear from me, okay?
But it just shows you the importance of a proper investigation, because all of these cases we talk about, the employer falls over when they haven't done a proper investigation.
No, it's the theme for today. You know, in some ways it certainly wasn't a deliberate theme, but as we've gone through the cases, we had 3 cases today, all of which, had an investigation been done appropriately, would have stopped the decision making that was made. And investigation doesn't have to be with lawyers. Okay, it doesn't have to be with special aid investigators. You can do them yourself, but can you follow the structure, you know, that Kim and I gave you, I think about 6 months ago, the tick list of things that you must do. Go to your policies and procedures first. Okay, good, I've got those. Create a tick list of things that I must do in the process of doing my investigation. Then look at the allegations. Create an allegations letter that says when, where, what exactly. Make the person agree that that is it. Okay, then take that out and test that allegations letter. Don't make witness statements unless you absolutely have to, because people finesse witness statements. I'll send it to Kim and she goes, yeah, I know that's what I said, but that doesn't look good for me. Take written notes. You're allowed to use those and rely upon, but make them contemporaneous. Do them at the time of doing it. Confirm with an email back to the person what they said. Okay, more contemporaneous evidence. Doing a good investigation is not hard, but knowing the standard of proof and the rules around evidence collection and weighing evidence is absolutely critical. Okay, good. Well, why don't we go into the case study?
I like this one.
I like this case study. I've sent it off to Nellie, actually, by the way, if you're watching, Nellie. This is my daughter. I've changed the name to protect the innocent.
Okay, Belle had travelled the world. When she arrived back in Australia, she found it parochial and sleepy. Her recent time in London had taught her how open and committed to safety the UK and Europe were. She returned to her father's law firm, WCF.
Yeah, back to
lawyers.
front. You
Yeah.
say that? Yeah,
I did
FCW. You
notice.
like that? Yeah, it was good, wasn't it?
He was in the process of selling his firm when she arrived back. On 30 June 23, he worked his last day and the new owner took over the reins on 1 July. It didn't take long for the new owner to show his true colours. He was prone to being bombastic, vague in his directions, and petulant when no one read his mind and met his expectations. None of this was directed at Belle, but she saw it happen. She also heard his comments that were dismissive of women's primary care obligations for young children, such as, "I know life is hard, but we still have to hit our targets," and dropped back to 1970s vernacular. Calling women love, and was frequently heard talking to other men in mock whispers around the way women dress, such as, "Doesn't Ivy look stunning today?" and commenting upon body shape and appearance. He never directed at any specific woman, but it was common to hear his conversations with Gill and other male lawyers in the kitchen around looks and appearance, followed by cackling laughter. Belle had had enough. She asked to speak to the new owner, Gus, in private. When they were alone and the door shut, Belle said she had observed his and other men's behaviour to women. It was unacceptable and had to stop. She went on to say he seemed to lack self-awareness around his management style and it was causing stress to other employees. He struggled with the feedback. He said thanks and he would think about it. 2 weeks later, he asked Belle to come to his office. Gill was present. He said that she had repeatedly attended late, which was true. Belle arrived every day at 10 a.m, but always hit her billable targets and often worked until after 8 p.m. And this was the first she knew that he was unhappy with her time of attendance. Seemed disinterested in adjusting to the new culture and rules, and she was no longer a cultural fit. Okay, so that's what he said to her.
Yep.
Belle smiled. She said, "Gus, you are a weak prick. You'd make me swear."
I knew you'd say it.
"I tell you that you are hurting people and now you have cobbled together rubbish to get rid of me." Gus exploded. "How dare you call me a weak prick? Get out. You are now summarily dismissed for being rude and abusive."
Love it. Okay, did Gus breach any legal obligations in his case study?
Quite a few.
Yeah. Can I just say this is a hostile workplace argument?
Yeah,
so
exactly.
There's two things. There's psychological hazards,
Yep.
which is clearly the failure to articulate what he wants, the unreasonable expectations around work,
Yep.
pure psychological hazards. Also psychological hazards in the manner in which he treats and describes women. So there is behaviour which is sexually inappropriate and discriminatory in a generalist level, but that is what a hostile workplace is, and you have a positive duty to stop it.
Yeah.
And therefore he's also in breach of safety law obligations.
Yeah.
Okay?
Yeah.
So not bad, is it?
It's a good one.
It's a good one, yeah. Did Bell's words to Gus justify sacking?
I don't know.
No. The answer is so displays of brief displays of anger,
Right.
which are not designed to hurt but are just expressive of frustration, will never be a basis for summary termination. Okay?
Good.
Which is lucky with you and I. We do it to each other every now and again. We don't sack each other. Does Belle have a good general protections claim? Any other possible claim in safety law? She has a ripper general protections claim, and she'd win.
Yeah.
I don't think she has a lot of damage, but
No.
but general damages are starting to go up in general protections claims. So she's probably got a 20 to 30,000 general protections sort of claim, and the loss of work going forward, the power to reinstate. But given the nature of who he is, there'd never be a reinstatement. So yeah, between 30 and 50 grand. It's a good claim. They'd want to settle because it would be brand destroying not to settle it. Yes. As Latouf has shown in the case we dealt with earlier, how destructive that can be. And yes, there's a safety claim because she raised safety concerns and it's discrimination. So he's up for penalties as well, up to 50,000 personally and 250 for business. So interesting, isn't it? Safety law not being used in the last 2 or 3 years like this. Plaintiff lawyers have just started to learn how to do it. There was a Patrick's case 4 years ago, but we're now starting to see it happen. And the safety regulator themselves is starting to focus on it, particularly given their penchant for intervening where there has been sexual harassment. So you may have a safety regulator knocking on your door. Okay. Could Gus, Gill and WCF face safety prosecutions? Yeah, they could. Yeah. Are they likely to do it just at this moment? In Victoria, I think there's a reasonably good chance. Most other jurisdictions, no, although both New South Wales and Queensland are getting there. So I think in a year's time, we would see this type of thing quite possibly prosecuted, particularly where there are strong Labor government directions around the treatment of women and where WorkSafe or whatever their name is has been given a direction about it. We may see higher levels of intervention. Okay?
Good.
Look, that's it for this week. It's great doing it with you again.
Yeah, thank you.
You noticed the words I put in for you? I
Yeah,
got you,
thanks,
didn't you? I
Andrew.
sucked you into it. I sucked you into it.
Do your best, don't you?
Great to chat. Lovely to see you all, and we'll see you next week.
See you.
Cheers. Bye-bye.
Bye.